Every conversation explores the art of thinking beyond the obvious. And today I have my special guest. He's a CEO at American Rights Alliance, none other than Mr. Ivan W. Turk. Welcome, Mr. Ivan on Abstract Essay. And can you please introduce more about yourself that I missed?
Of course. So, thank you for having me. My name is Evan Turk, Turk. I am an attorney in the sunny state of Florida, also admitted to practice in New Jersey and in front of the United States Tax Court. My background is an asset protection attorney, estates, trusts. We do some family law and the focus of protecting wealth, making sure it's multi generational, doesn't leave you due to a divorce. I also have been doing big First Amendment cases, and as a result, I was asked to create a charity on First Amendment rights called the American Rights Alliance, which I am the founder of and CEO.
Well, thank you so much for sharing your knowledge and wisdom to the world, Mr. Ivan. Thank you. And today, let's talk about asset protection during divorce, how to safeguard your empire. Before we get to into tactics, what was most critical psychological or mindset shift an individual with a significant wealth must make when they first realize a divorce is possibility?
You have to understand your net worth, and a lot of clients they are. It's funny if you look at when you file your tax returns, what you think your net worth is for the tax man, versus if you're applying for a business loan or a personal loan, what your net worth is. So you have to
Mm,
understand how to really value your net worth. Also, what we recommend for an asset protection strategy, as well as being because it's the right thing to do, is incorporate a family limited partnership or some sort of structure where you can ensure that your wealth is multi generational. And as a result of that, if done with clean hands, that's a great way of reducing your actual net worth because you restricted your access to your net worth and you made sure that the focus is on creating a legacy for your children and your children's children and thereafter. So that's the first thing first two things: know your net worth and find a way to make it last multi generational.
mm. Interesting answer, Mr. Ivan. The term equitable distribution is often used instead of a 50-50 split. What specific factors do courts weigh to decide what is fair, and how can someone prepare for the analysis?
So, equitable distribution, the default rule is 50-50 in order to distribute your assets that are jointly held between both spouses. However, that doesn't mean that those assets are equitable because let's say the one of the spouses received an inheritance from their parents. Is that inheritance that greatly increased the family net worth? How do you account for that? And what you do is you make sure that that wealth stays in the one spouse who received it and it doesn't become a joint asset because that shows the intent. The intent was to keep it as a joint asset or as a non-marital asset. Equitable distribution is based on joint asset, marital assets, not non-marital assets. So if someone comes into a marriage with a significant net worth and never commingled those funds and never treated them they were marital assets, more likely than not, they will not be considered a marital asset for the purpose of an equitable distribution.
So, Mr. Ivan, Asset discovery is often the first major battle in a high net worth divorce. Are the most common places where assets are unintentionally hidden or conversely deliberately obscured, and how are they uncovered?
They're often in businesses, the main business, secondary, tertiary businesses. So they're often uncovered by a forensic accountant because there are bank returns, and sometimes you need to have access to business records because the intent is to obscure the net worth by keeping them, hiding them, not disclosing them in business structures, whether it's the existing business or often separate entities, LLCs, and tertiary financial strategies that are set up in business holdings.
So, the coming of assets, Mr. Ivan, is it a recurring theme that turns separate property into a marital property or beyond the obvious joint account? What are the subtle everyday ways people accidentally commingle, and how can they be avoided?
Joint accounts or joint expenses taken out of a non-marital account. Um, the biggest mistake people do is they have horrific financial records. So one of the things you really need to do is have a great bookkeeper that can isolate and identify. A lot of times, people think, "Oh, this is a business expense," but they're paying personal expenses out of the business, and that automatically can set up an issue with an argument that the business is, you know, the alter ego of the spouse, and therefore fair game.
Fair game indeed. Let's talk about the advanced strategy structuring, Mr. Ivan. For someone bringing a family business or a successful startup into a marriage, how does the law distinguish between the value they created before marriage and growth during it? What strategies legitimately protect the premarital enterprise?
Well, we have to assume there is no prenuptial agreement. So tax returns are a good example of what the value was prior to marriage. If you applied for a business loan, um, as well, it would state what you think the value of the asset was, and you really would have no reason to try to limit the value of that net worth because you're trying to get a loan. Often, what we see, however, is companies that a spouse contributed. I have an event I'm going to on Saturday with someone that it was a very well known, one of the top uh, Fortune 500 companies in the world, in this country, but in the world. But what happened was the spouse really was there at the beginning when the whole idea of this company was created, and she was involved in it throughout the process. Although she was salaried with a limited purpose role, she was a technology department. Um, we had to identify and explain to the courts that there is a value here, and there's a without her contribution, this company would not have even taken off. So a lot has to do with how you structure your legal arguments, but that's only when you don't have clear identifiable documents and a prenuptial heading into the marriage. Then everything, like I keep saying, is open game. So you want to protect it as much as you can, especially the spouse who has contributed blood, sweat, and tears towards the business, but can't articulate um, their financial contribution because there may not be. But that spouse may have said to the breadwinning spouse, "Hey, let's not go on vacation. Let's put off having children. I don't need to go back to school. I'll work for you and for this company. And all of a sudden, the company grows 10x, 20x, a million X. And that spouse is left in the dust without clear, um, you know, explanations and proof, validation, and support.
Trusts are frequently mentioned as a protection tool, Mr. Ivan. Can we demystify when a revocable living trust is useless in a divorce versus when an irrevocable or discretionary trust can be a powerful shield?
It's all about control. So irrevocable trust gives the grantor, the trustor, trust maker, all the same, just different terms for the same position. Gives them the power to pretty much make all the calls and all the shots. So for asset protection, it only becomes valuable upon death because that revocable is now automatically irrevocable, because due to the change of circumstance, the life. But while you're alive, if you could call the shots, then it really provides no asset protection, and often doesn't do any difference than keeping a separate bank account in your name, um, and trying to say that it's a non-marital asset. The only way around that often is by encumbrances, liens, and loans that have to get paid before the owner can get access to his or her own money.
Let's talk about the inheritance, Mr. Ivan. If someone receive an inheritance during the marriage, what is the exact step-by-step protocol to keep it legally separate from day one? What is the one mistake that instantly nullifies that protection?
The inheritance goes into a joint bank account or a bank account that has both access of both spouses. That's the direct no. Don't do that. You're killing me here. Don't. But merely putting in your own name is a much better step. But you also have to show intent to not keep it as a non-marital asset. So this is when a revocable trust or irrevocable trust could help, because in that document you can state what the purpose of this money and the purpose of the trust is: to protect this inheritance so that it cannot be construed as a marital asset, and accordingly any distribution shall be limited to the role of a um, non-marital asset.
Mm, interesting, Mr. Ivan. For high earners with complex compensation, stock options, RCUs, deferred bonuses, carried interest, how are they typically treated as divided? What questions should they be asking the HR or their lawyer?
It's a great question. So in Florida, and that's where I practice, there's a thing called a quadro, qualified domestic relief order. That's typically used for retirement accounts, but it's the same theory. Let's just say you have a stock option that's worth um, $10,000 is what the acquisition price was, but if you exercise that stock option, it's now worth $1 million. Um, but it's not really worth $1 million because 99% of that stock option is going to be subject to income tax. What and you may or may not choose to exercise that option, and you can't compel, or at least want to include the court to compel the other spouse to withdraw or exercise that option. And sometimes it has not matured yet, so you can't. So this is where forensic accountants make the big bucks, because what they do is they get an evaluation of what the present value is. A bird in the hand is worth two in the bush. So they'll do an analysis, and both sides can do an analysis. It's up for the judge to decide, um, somewhere in between what the value of those options are, or you know, the the cash value versus the long-term value of that asset, or the present day value, I should say.
Mhm. The prenuptial and postnuptial agreements, beyond having one, what are the specific clauses or provisions that make these agreements particularly robust or conversely vulnerable to being a challenge in court?
Failure to disclose is the biggest one. It's another is duress. Right before your wedding, you say, "Hey, I need this signed." Adequate disclosure with not only adequate disclosure, but having the other spouse have independent counsel so that you can't say, I was forced to do this, undue influence, duress, all of those arguments that can justify bringing that asset back into the marital estate. Those are the biggest. But another is failure to disclose options and the value of those options, the present value of it, and um, any other businesses that you may own or have an option to exercise going forward.
Mm. The divorce process and negotiation, Mr. Ivan. The business valuation is often most contentious point. Can you walk us through the three main approaches, just like asset, income, market, and explain which type of business each of one favors?
Well, there are different types of businesses that have completely different analysis. For example, if you're a doctor and you have a medical profession, the value of the medical profession requires a license to practice the same thing as a lawyer. Another is the actual involvement of the spouse. Um, so the way you would really have to do this is not just get an evaluation, but get an evaluation as to what that medical practice is. As somebody can't own it because they're not a doctor or not a lawyer. I mean, that basically converts it into an analysis of what is the income and the future value of the income value, not the equity value in that business. And that could significantly reduce the value of the asset because of lack of marketability. I mean, you can't sell this to everybody. You can only sell what the value is, which makes it much lower because you really don't have management or control over the day to day because you can't.
Mm, yes. Once a business is valued, what are the creative settlement structures beyond the simple layout or buyout? How might offsetting with the other assets or structuring a phase payout work?
Everything is negotiable, typically, because we always say you get in front of the judge, but 90% of the time you do not. So what you really have to do is figure out what each spouse is willing to accept and prepare it so that you're going to trial and have a list of experts that are going to fight this tooth and nail to make it very difficult, especially with high net worth clients. I've seen divorces that are 10 years and going forward, and sometimes they agree not to get divorced because they will never agree and they don't want to go to court because it's just going to cause a lot of interruption, especially if you have a business with other business owners. And, the divorce is going to require the business to reallocate assets at the expense of the other shareholders. And there's all these major components. So often in a negotiation, that is brought in and say, what is reasonable? And it's often a payout over time based on future income.
Mm-hmm. Yes, definitely. So beyond the legal structure, what practical relationship dynamics with the ex-spouse, especially when co-owning a business or assets, are necessary for long-term stability?
It's really boils down to the relationship you have with the ex-spouse, and the relationship of the business with both spouses. often I see both spouses have really worked into the business, and they're grown up enough, mature enough to work together going forward, although they may not want to be with one another. But that's in a good situation. I mean, the good, the bad, and the ugly. I'll tell you what the bad and the ugly are now. The bad is interruption in business, and one spouse wants just to buy out, and that will slowly devalue the business because that spouse was important. And the ugly is when one spouse just doesn't care about the business or the employees and just wants what they think is fair, and they'll do whatever they can. And in the state of Florida, there's about 100,000 attorneys. They could always find one attorney. You could always find an attorney to battle your battle, even though it may not um, do anything except frustrate the system. And there are many attorneys that just are really good at draining the other side of in legal fees and unnecessary litigation, drawn out litigation, depositions, deposing all parties, inconveniencing everyone. So when they do those malicious tactics, they often get, or hope to get more than they would be entitled to in court. They just really want to beat you down, and that's really when it gets ugly. And then there's a PR side of it too, because when you have the disclosure in a divorce, a lot of that is of public knowledge. And a lot of times that public information is going to affect the business negatively, and you want to do whatever it takes to protect that. And quite often, that's a tactic, a leverage tactic from the divorcing spouse that thinks that he or she can get more than they would otherwise get. And unfortunately, I've seen it, you know, prevail more often than you would wish.
Yes, so before we wrap up our discussion for today, Mr. Ivan, I'm inviting you to please do listen to my other podcast, people. My other podcast, because my abstract essay is already in sixth season, abstract poetry in third season, and of course, my book 101 review in sixth season as well, comedy 101 third season, and food 101 in sixth season as well, geography 101 love letters, movie 101 review, music 101 our fifth season. Science 101, Sex 101, fifth season, and of course, Law 101, Trivia 101, Mental Health 101, Motivation 101, Entrepreneurship 101, and Bible Verses 101 are my baby podcast. Please listen to them wherever you listen your podcast. So, Mr. Ivan, let's explore a complex scenario. A family cottage was purchased by one spouse parents, but the marital funds paid for a major renovations. Who has a claim to what and why, or and how messy does this get?
It's a, I had
Mhm.
a similar case like this, and even though they put money into the renovations, the argument was that that was a gift,
Mm.
because the intent of the one spouse, they never commingled the assets, they never titled the assets jointly or anything other than a non-marital asset. So the person who put all that money in as in renovations is it was out of luck. I mean, that's when you really have to lawyer up and come up with interesting legal arguments as to finding anything that could persuade the court otherwise. But those renovations by itself are just considered gifts, at least in Florida.
Only in Florida, people, the Sunshine State. And thank you so much for sharing your knowledge and wisdom to the world, Mr. Ivan. So, can you please invite the listeners to support your business, your advocacy, or anything you want to promote on Abstract Essay?
Yeah, absolutely. So my business is turklawgroup.com. It's easy to remember Turk. It rhymes with jerk. And family law brings out the best and the worst of people, typically the worst. You can find me
Mm-hmm.
at turklawgroup.com or on social media under Evan Turk or Evan W. Turk. And for my charity, which is the website that's showing up there, it's the American Rights Alliance.org. and we're doing a lot of cases that are affecting First Amendment laws on the national level. And under your favorite social media, we are at Donate ARA or at ARA Donate. So please find us.
Mm,
Don't be, yeah, we
hesitant.
don't want to be a secret.
Yes, people, let's support Mr. Ivan W. Turk because if you support him for sure, more and more empowering advocacy like this to rise. Will you be my guest on Low 101, Mr. Ivan? And let's talk about something that is good over there. Please do come over
Absolutely.
and well, let's promote your business, let's promote your advocacy. So I have one more question. Finally, if you could give only one piece of a non-legal strategic advice for someone entering this process with significant asset, what would it be?
Non-legal. Okay.
Non-legal, please.
That's a great question because everything is legal, but
Yes.
emotional. Know what you're getting into, and don't overlook the signs that the spouse is doing it for the wrong reasons. Don't get your heart making decisions that your logical mind won't normally accept. And if you can't understand that, ask your family members to chime in and your trusted friends, because these are the people who are going to be your support group if it fails. And although half of a billion is, 500 million, you don't want to give a divorced spouse 500 million or 500,000 for that sake.
Mm-hmm.
Think with the right brain.
Yes, definitely. Thank you, Mr. Ivan. Looking forward for our episode on Low 101. Modicom people, see you soon.
Thank you.